Good morning, good morning, good morning. Sorry for being a few minutes late. We were grabbing some last minute documents because we shifted and added a topic today. I am going to be doing a first look at another YouTube defamation suit that apparently I mentioned in. When I say first look, after y'all told me in the chat yesterday, you're like, did you see? And I'm like, no, I decided to just not see and do it today. And then I was on Twitter this morning, as one does, and it looks like there are some new documents in the Amber Heard insurance cases wherein she might be claiming that she, in fact, does not have a domicile. So I'm going to go look for those documents while we are together because I am very interested to see where that information is coming from and what is being said. So we're going to pull those up and look through them together and see if we can suss out where that's coming from. There was just a hearing, and that hearing has a minute order. So we're going to look at that minute order, and then we're going to go to Nate's lawsuit. So this is what I'm looking for in those two suits. And I'm very interested to see what happens there. So hopefully we can find the documents, and that's what we're doing. So that's where we're up to. All right. With that, welcome in. It's time for coffee and cursey words. I have coffee. I have cursey words. I have questions this morning too. And I have my I have questions shirts on. Let me know what you are drinking, where you're coming in from, and we're gonna talk about the things. We don't even have a thumbnail on today's video. Why? Because I was up very late recording the podcast last night. Do you guys want a preview of the podcast? Maybe we'll do a preview of the podcast somewhere in this whole thing. But we need to roll. We need to roll. So Celine's asking if we sent out a text. No, we're having some quirks with the text crew this morning. So no, the text did not go out this morning and won't. I'm going to go add that on Patreon. Look, we've been having text issues since Heard, since the company we were using was like, oh, by the way, we're going to completely change your entire contract and it's going to make everything very difficult. So there have been issues with the text crew since then. We are still looking for a new service. And someone reached out during the Heard case, and we are going to be reaching back out to them about potentially a new service. So it is ongoing. It is ongoing. So I'm going to send that out through the notifications over at Law Nerds Unite. Look, if you can't be a member, there is never any shade. Never, ever any shade. Never a problem. Your support is much appreciated. It is never expected. You can go over to lawnerdsunite.com and follow me. And when you follow, you will just see these updates. You don't have to pay to get access to the other stuff. So that will always update you. Yeah. We have a lot to talk about, and these go out pretty fast. So if you want to do that, that is something you can do at Law Nerds Unite. For those of you on mobile, I saw it yesterday from Rob from Law and Lumber. There is a new feature that some of you might have access to on mobile. I'm going to get onto my phone and see if I can see it, where you can see like hearts, almost like an Instagram live. So if any of you are on mobile, you can go ahead and play with that and let me know your thoughts, because it's something that I think YouTube might be rolling out, but I'm not 100% sure. Sometimes they test out features. And since my channel streams so much, I'm not surprised that we're getting a test feature on the channel, but I need to mute me. Oh, I see it on my phone. So down at the bottom, there is a little like button for hearts and stuff. So you can absolutely go see, you can go see all the different like emoticons you can use, like a I don't know, Instagram live or a TikTok live or whatever. So you can go use those. I wonder if you can customize them. You guys will have to try and let me know if you can customize them, but that's pretty fun. There are some emojis down there too. So you can absolutely check that out. If you are on mobile, it looks like those of you not on mobile iOS don't have it. So we'll see. So some of you have it, some of you don't. We'll just see. Again, new. Will it be distracting for you? I can't see it on my end. Which bums me out. I hope that I'll be able to see it in the future, but no, it won't. Thank you for asking. You guys are so kind. So don't see it on Android. Okay, I'll ask. And not everyone on mobile iOS. If you have not updated, the the YouTube app recently, that might be part of the problem. The YouTube app has recently updated. They've changed a bunch of layout stuff. This is all like behind baseball YouTube stuff, but they've changed some layout stuff. So Marissa, it's not members only and should not be members only. It should be available. So if you haven't updated the app, we'll see again on Thursday and check it out. So, yep. So a lot of you saying you have it on iPad. Cool. So anyway, let us see. And again, new features might not always work the way you think they do, but it's funny because I can see the Facebook emoji. I can't see these. So again, these are all things for me to ask YouTube about when I see them. So coffee, we're going to do a little bit. Of research together to pull this document up. We're going to go through a little bit of the Amber Heard insurance cases, and then we're going to do a first look at this lawsuit that apparently I mentioned in. For those of you that are new here, you might have missed the previous times I've been mentioned in lawsuits. Lawyers like to talk about me. We'll see. We'll see if this time it's more flattering. Hopefully there's a link, at least a link to the website. Can we link a girl? Can we send a linky poo for me? No, I'm teasing. Let's roll the intro. Replay crew. There will be timestamps down below. Let's start with the insurance stuff first. Let's do that. What do you think? Yeah? Curious? I'm curious too. Let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So for those of you that have not been following the post-verdict Johnny Depp Amber Heard, I think all of us are going to learn that post-verdict, like the things lawyers know that everybody else is like, oh, the verdict's over, and then everyone moves on. There's no moving on. Post-verdict is still very busy. So in the post-verdict Johnny Depp Amber Heard world, this is what's going on. Amber Heard's insurances have sued one another over who's paying for shit. And they are saying, one of the insurances that paid for her lawyers is saying, you also had a claim. You have to pay us half. Pay it. Pay us half. Pay your share. And the other insurance company's going, she doesn't even go here. We don't know her. What the fuck are you talking about? You let these attorneys run wild. You paid them everything that they asked for, well beyond what the standard insurance rates are. So what we're not doing is paying. Oh, and also, we don't think we have to. So they then, New York Marine, went and sued Amber Heard and was like, we're not paying you. They're mostly looking for declaratory relief from the judge. Declaratory relief means they are looking for the judge to declare, I do declare. That's declaratory relief. Just think of it in your brain. I do declare. They're looking for the judge to declare what rights Amber Heard has under the insurance agreement, what rights the insurance company has. They're looking for, hey, take the law, you take the good, you take the bad, you take... Emily, is your ADHD on fleek this morning? Apparently. You take them both and there you have. So they're looking to take the insurance agreement, the law, and have the judge say, you have to do this, you don't have to do that. That's how this is working. The insurance company's position is, hey, so that like jury verdict with like malice and stuff, we don't have to pay you. That's what they are looking for a declaratory judgment. That's what they're looking for a declaratory judgment in. We don't have to pay anything. And she might owe us money. She might owe us money back. So then the two insurance companies are fighting over who has to pay who. The insurance company that paid for the litigation seems to maybe be maybe take the maybe with this, seems to maybe be paying for some of the appeal too. And they don't seem to be asking for money back. They seem to be asking for money from the other insurance company. And that seems to be what they are looking for. So with that, there is a case in the Southern District of New York between the insurance companies, Travelers, and New York Marine. And there's a case in California federal court between New York Marine suing Amber Heard. That's the position of the case. That is the road so far, if you will. There is a tentative ruling from October 18th, and then there was something new that was published today. So we are going to go look at those things together. Emily, is this a research stream? Yeah, Emily was up really late recording the podcast, and I saw this morning on Twitter, and I was like, I wonder what document that's in. Let's go see if we can find it. So we're just going to do it together. We rarely do a research stream. Emily is normally prepped and ready. Emily's not ready for anything today. It was Halloween. My kid dressed up in like his little My Chemical Romance fantasy. It was so good. It was so freaking good. My kid looked amazing. And then my mom is like, is he David Bowie? No, Mom. Somebody asked him when he was out and around. They were like, who are you? And he's like, Gerard Way. They're like, oh, that's weird. Because you looked like the guy from like the Welcome to the Black Parade and the Helena video. And he's like, same. That's same. That's same. That's same. That's same. So he had a great night. It was a lot of fun. Pictures, no, I promised him I wouldn't share. I promised him I wouldn't share pictures. So he's a teen. So I promised him I wouldn't share. My little one was a Jawa. He even had like little light up eyes. It was great. So he was in his full like emo love phase. He's like, God, the early 2000s are awesome. I'm like, yeah, buddy, I get it. I was there. You were born in the mid 2000s, so I'm sorry. Anyway, he loves it. He was so excited. So yes, my brain, Brittany said, my brain just went, did Emily just say My Chemical Romance? Yes, I did. Yes, I did. But my mother was just like, David Bowie. I'm like, no. So I had to send her some pictures. I was like, mom, there you go. So it was a late night. So is this a long way of me explaining why I'm not prepared? Yeah, yes, I'm normally more prepared for streams, but between travel, I don't think I've stopped moving except for the like week and a half that I was literally physically knocked on my ass by the panini, the coronavirus. I was just knocked on my butt. So other than that, it has been like travel and this and that and this and just so today we're doing a research stream together. Let's take a look at this minute order. This is whether or not the cases are going to mush together and be in one place. If you want to follow those, I have other videos where I cover all of these motions. The shade is fucking brilliant in these motions. These attorneys are like this and that, and then they throw in some other stuff. It's actually been really fun to see just the attorneys and the insurance companies kind of have their moment. So we've been covering that. There's a tentative ruling from the court. And let's see what the court wants after this tentative ruling. Oh, that looks way too little. We need that to be bigger. Why is that still so little? Oh, because that's the wrong screen. That's the wrong ruling. I was like, why is that so small? Because it's not the right one. That's why. Let's see if this is the proper screen. There we go. She's in business, folks. Look at us. We are professionals here. Whop, whop, we're professionals. We're professionals. Also me, hitting two buttons at once that I didn't intend to hit. Perfect. It's just perfect. Today is perfect. I'm loving a stream today. I'm loving it. All right. In chambers, tentative ruling. What this means in this minute order. In chambers means They didn't do this in open court. They did this in chambers, or the judge just did it. And is issuing it from chambers, not from the bench. Tentative ruling on plaintiff Travelers Commercial Insurance Company's motion to consolidate this action filed by Travelers with the action filed by New York Marine against the insured Amber Heard. Attached here too is the court's tentative ruling on plaintiff's motion, set for hearing on October 20th. So, hey, we're giving you a heads up. This was filed October 18th. So this is right before the hearing. Hey, we're giving you a heads up. We might be ruling against you. This also lets the attorneys know what they're facing when they're coming into court. Travelers Commercial Insurance Company versus New York Marine. Tentative ruling on motion of plaintiff's Travelers. We already know that. Plaintiff Travelers Commercial Insurance Company moves to consolidate the action filed on July 20, 2021 for all purposes, including trial, with New York Marine versus Heard, filed July 8, 2022, after the conclusion of the underlying litigation involving the common insured. After the trial in Virginia. New York Marine and General Insurance Company, I'm just going to call them New York Marine, it's too long, has opposed the motion. New York Marine is a defendant counterclaimant in this action and plaintiff in the other action, which is filed against the two insurance companies, common insured Amber Heard. This court will almost certainly grant the motion. I'm a little surprised by that. Truly, a little surprised. This court will almost certainly grant the motion. I thought New York Marine had some really good arguments. The court disagrees. Yes, this judge is absolutely practicing law from the bench. That's exactly what's happening. This court will almost certainly grant the motion, but believes that allowing consideration of Heard's position, if she has any to offer, is the wisest course before it makes such a determination. Heard apparently has not yet appeared in the New York Marine action, and we're going to go double check the docket, but it seems like she has not appeared in the other action and has some time to do so. It's interesting to me that they will certainly grant the motion, but Amber Heard's attorneys through Travelers said, why didn't we get to say anything? We haven't even answered yet. So that's interesting. Under the FRCP, if actions before the court involve a common question of law or fact, the court may 1, join for hearing or trial any and all matters and issues, 2, consolidate the action, 3, issue other orders to avoid unnecessary cost or delay. I wonder if Emily, keep reading me. I wonder what the court's decision is. The court's decision. I wonder if this has to do with the fact that so much of the insurance actions are going to be depositions of lawyers, including they're trying to depose Elaine. So many that they are trying to consolidate. So I'm just wondering. Marilyn said Laura B has the documents. I'm sure they're in here. We just haven't figured out which ones yet. We're going to get them. That's not a problem. It's just which ones are we getting? We haven't had a chance to go through it, so we're doing it together. The court's decision on a request to consolidate is discretionary. So I wonder if the argument that the lawyers are all going to be deposed, and the lawyers are like, I'm only going to be deposed once. Like, fuck this shit. I'm not going to be deposed twice. It's sort of the same, but not. I think some of the legal issues underlying are different. But it's sort of the same. So I think that might be a big factor for the court here. The court's decision on a request to consolidate is discretionary. The court can do what they want. I get to do what I want. Heard in a Cartman voice. I do what I want. The Travelers action current operative complaint is the first amended complaint, the FAC, filed September 7th, 2021. There's videos on that on the channel. It contains claims for declaratory judgment, equitable contribution of defense expenses. New York Marine answers the Travelers FAC on March 25th, and at the same time asserted counterclaims for declaratory relief, that New York Marine did not owe a duty to defend the insured through independent counsel, declaratory relief, that New York Marine did not fail to provide a defense, and declaratory relief for reimbursement. I do declare, Your Honor, I need you to tell me whether or not we have to pay this woman that we do not want to pay. That we do not want to pay. They don't want to pay. The New York Marine FAQ contains 4 claims for relief against Heard, declaratory relief as to plaintiff's duty to indemnify Heard for the judgment order. Hey, we're not paying her judgment either. The insurance company's like, what we're not doing is paying out Johnny Depp. No, sir. She has to pay it. She has to pay it. She has to pay it. Also, by the way, when I do declare in my head, I picture myself in The Office, the TV show, doing their murder mystery party. That's where my head's at. That's the inspo, if you will, for the voice. That is the voice inspo. 2, declaratory relief as to plaintiff's duty to indemnify Heard for the judgment. Declaratory relief. This is all just, Your Honor, tell us if we have a duty to do any of this shit. Duty to defend. Under California Insurance Code 533. This is, I think, what they're trying to get around, because California Insurance Code 533 very clearly says intentional torts, you don't got to pay. Guess what public figure defamation is? Tell me, chat. Give me something. Come on. Hit it. Yeah, intentional. It's intentional. It's a genre. 4, declaratory relief as to plaintiff's duty to defend and indemnify Heard in the underlying action under the policy. Travelers believes that New York Marine did not provide a proper defense in Heard's underlying litigation. Yeah, well, here's the thing, though. New York Marine says that Travelers' lawyers, Elaine, took them off of pleadings, excluded them from communications, and basically hip-checked them out of this litigation. So New York Marine is like, fine. New York Marine had the first lawyers on scene, and they said, we will be lead counsel. We will control this. Travelers wrested control from the New York Marine lawyers through their own lawyers, and then paid them whatever. And then New York Marine was like, their lawyers are like, fuck it, we're out. If you're not going to work with us, we're out. And then they were out. She elbowed them right out. So, Marisha, they are suing each other, and New York Marine is suing Amber. This is the motion to see if those 2 litigations will be heard together. And it looks like the court is inclined to acquiesce to the request of Travelers. So here we go. You scared the crap out of me. What are you, a ninja?
So, I was just coming by to make sure you had coffee and water.
Thanks, Dr. B. I have coffee and water. What I don't have is a soul anymore, because it has now left my body. Because I am now deceased, because you scared the absolute life out of me.
Good Halloween reference, too.
This is Halloween. All right, thanks. Dr. B literally scared the life out of me. Sorry for the jump scare, chat. I literally didn't hear him come in. At all. When I tell you that I'm jumpy, it's because I am. But we'll always take checking to make sure I have coffee and water. We'll always take that. Okay, so let's see. Where were we? New York Marine's counterclaim in the Travelers' action, meanwhile, challenges the existence and scope of New York Marine's duty to Heard. I'm sorry, but in the Amber Heard cases, duty takes on a different spelling in my brain. It's like, duty. New York Marine also takes the position in the Travelers' action that independent counsel chosen by Heard and funded by Travelers obstructed, prevented, and or limited the participation of New York Marine's appointed counsel. The New York Marine action against Heard likewise contests the scope of New York Marine's duties to Heard. It also charges that New York Marine's counsel was prevented from assisting in Heard's defense in the underlying action. They did say all of that. They did. It's plain from the parties' briefing that, as Travelers asserts at the aforementioned discussion suggest, the 2 cases share common parties and common issues and will include common sources of evidence. As Travelers argues in its opening brief, New York Marine's scope of duty to its insured, its failure or success in satisfying that duty, and whether it is excused from performing it are the central legal facts at issue in both cases. So they took Travelers' position of this. The common ground is not outweighed by other considerations. Obviously, the issues that are common between the two actions are not the only issues in the action. The first involves a dispute between two insurers with a common insured. The second, a dispute between only one of the insurers and the insured herself. But the court agrees with Travelers that any risk of confusion of the issues and or any concern that the conduct of one party will be improperly attributed to another can be adequately managed with careful preparation by the attorneys, aided if necessary by appropriate jury instructions and verdict forms. If this goes to trial, it's going to be bananas. This is like deeply legal bananas between these insurance companies, and it's so interesting. This is all of like the behind the scenes legal. This litigation is just going to go on and on and on and on and on and on. All right. Moreover, this is not an overly complex situation, either factually or in terms of the number of parties. Who pays who? It presents a fairly straightforward three-way relationship. Tripartite. The court is saying it professionally. I'm not. A tri-party relationship involving two insurers and a common insured. As Travelers aptly summarizes things in its reply brief, the court is definitely on Travelers' side in this one. The court's assessment of the interrelated rights of the three parties should not be done twice with the potential for two possibly different results. So they said in their reply brief, and somebody said it's a throuple. Yeah. I mean, it feels like a very uncomfortable, an awkward throuple, a very unlikely cuddle puddle of insurers that New York Marine wants no part of. New York Marines is like, get me out of this cuddle puddle. I don't want a cuddle puddle. I don't want stacks of insurance documents. I don't want a cuddle puddle. I want to get the fuck out of here. And Travelers and Herd are like, but you can't leave. We haven't even begun. Give us your money. So what they're saying here is that the underlying consideration is what duty did New York Marine owe to Amber Heard? Because what Travelers is suing for is the rights owed to Amber Heard. Hey, you owed Amber Heard these rights, therefore pay us. And they're suing Amber Heard saying, we don't owe you this rights. And their counterclaims against Travelers are, we don't owe you these rights. So really that's about the beginning and the end of the consideration. What is owed to Amber Heard? And then what does New York Marine have to do or not to do with that information? So that's really what it is. I don't think they owe a duty. I don't. I think that the California law is going to absolutely yeet that possibility. But it has to be determined. It has to be declared. It has to be declared. Any concern about the delay from consolidation is drastically reduced here by the virtue of the fact that it is Travelers, the plaintiff in the action filed a year before the second, that is the moving party. So we don't care if it's delayed. We're asking for it. We're cool. Like if it delays, we cool. They've got a fuck ton of lawyers they've got to set up for depositions, and they've been wanting a delay in discovery anyway. Travelers is here for the delay. They've been wanting more time. It affirmatively acknowledges and asks for a new consolidated timeline that would necessarily cause delay in advancement of its own case. They did do that. Action by Travelers, the moving party here, would rather have the litigation done correctly than quickly. This judge is just like, I am on Travelers. On this, I am on Travelers' side. Travelers wants it done right, not fast. So all of you can sit down. What we're doing, if I'm New York Marine, I'm like, all right, well, that's done. That's done. We're going to be, well, this is going to get consolidated. That's strong language from a judge. Action by Travelers. Wait, let's see. This is a strange place for action. Action, but Travelers, the moving party here. Odd. Oh, here. Consolidation will require vacating the dates in the Travelers action, but Travelers, the moving party here, would rather have litigation done correctly rather than quickly. Travelers is the moving party, and it is not complaining about wanting to try the case to let the New York Marine action catch up. So they're like, we're cool. Can we all agree? In sum, far from adding confusion to the proceeding, presenting the events as part of a single story will only aid in comprehension, and there is little to nothing to be gained from having that single story presented to two different fact finders with the potential for inconsistent finding and judgments. It's fair. The court will likely grant the motion. I mean, Travelers made good arguments too. Travelers was like, all we're trying to decide is who owes what to Amber Heard, and that's kind of the central decision. The court will likely grant the motion, but will first give Heard an opportunity to weigh in before it does so. It will discuss with the parties present at hearing the best way of making that happen and presenting the opportunity. So let's go to what I'm optimistically hoping is this case's docket. Wait, this is, what did I pull this up from? Did I pull this up from California? Yes, I did. Let's go to the California docket. Stipulation extending time to answer the complaint as to Amber Heard now due November 21st. Amended complaint petition filed by Amber Heard, attachments proposed order. So let's take a look at this stipulation. Hold on. We're gonna pay for my documents. Let's get both of these. Yes and yes. Wait, I want to just view this one. Let's start with this. And then we'll have to go back to the stipulation. Normally, these are all just put together equally. All right. So this was filed yesterday in the Central District of California. Stipulation and Request. These are the attorneys for the defendant, Amber Heard. This is the first time Amber Heard's attorneys have showed up in this case. I'm guessing this is the document where we find out more. So I'm swooping it because I'm optimistic. We're all learning together, friends. So this is the first time Amber Heard's attorneys are showing up in court, because now the court in that minute order has said, hey, I'm inclined to grant this consolidation, but we've heard from Travelers Insurance, we've heard from New York Marine. Who we haven't heard from is the third person in this thruple cuddle puddle, and that's Amber Heard. So we need to hear from Amber Heard if Amber Heard wants to be heard. That's going to get confused. Tomorrow's podcast, I'm talking about people going to Elizabeth Holmes's home, and today we're talking about whether Amber Heard's going to be heard. Universe, I appreciate the tongue twisteriness and that I live stream, but come on. But come on. So, good morning, Allie. Good to see you. Let us see what Heard's attorneys say about whether Heard wants to be heard. Yes, Rob, the red lights are already on. It should have been a warning. We're already in the fuckery today. The lights started red because of Twitter. Stipulation. Whereas defendant Amber Heard's deadline to respond to the New York Marine General, I'm not reading that whole thing, is today, October 31st. Whereas Ms. Heard has not previously requested an extension of time to respond to the first amended complaint. Whereas Ms. Heard has advised plaintiff New York Marine of a jurisdictional infirmity. And has requested that New York Marine voluntarily dismiss this action, and has asked New York Marine for an extension of time to respond to the first amended complaint, whereas the parties are continuing to confer as how to proceed, whereas New York Marine and Travelers did not oppose extending the deadline to respond. Ms. Heard respectfully requests the court grant an extension of time to respond through November 21st. So this is an extension of time to respond to the complaint in the New York Marine circumstance. We're going to have to go to the attachment. Jurisdictional infirmity is a real new way to say jurisdictional issue, jurisdictional quirk. I don't think they can say subject matter jurisdiction. I don't think they can say personal jurisdiction. I think that the insurance policy, and I know there's a bunch of attorneys in the chat, so you are welcome to chime in as we do this first look together. The insurance policy was purchased in California for a property in California. I don't think you get to now say I'm not domiciled in California, so your rules don't apply to me. I guarantee you, that's strong language for a lawyer. I would be shocked if this insurance policy doesn't have a choice of law provision in it that says if there's any issue under this, we just sue here. This is not going to get very far with the jurisdictional infirmity. Don't anyone tell Daryl Brooks this language, because we're going to go from subject matter jurisdiction to, Your Honor, you're practicing law from the bench, and that is causing a jurisdictional infirmity. Don't ever. I don't think there's an arbitration provision because they've filed this suit, but I bet there's a choice of law provision. Laura B is saying it's commercial insurance, not home, but the yes on this one. Thank you. But this one was purchased in California, and California law is governing because they're applying California law. I imagine that there are choice of law provisions within this contract. It's an insurance contract. Of course there are. I don't know if there's grounds here. Diamond Boy says, yes, there are a lot of attorneys here. I am one, and choice of law. I can't imagine a policy that's going to actually not have a choice of law provision when they want California law to apply, because they are in all their complaints applying that California code provision with regard to intentional torts. So I don't think we're going to get here, but I really want to see what they have to say about it. So let me download this so I don't have to pay for it again. And let me go grab the attachment on it. Is there any more? There's got to be more. We'll see what else there is. We're just going to go through the docket together today before we get to Nate's lawsuit, and then we'll get to Nate's lawsuit. So proposed stipulated order. This will get granted, having considered the parties' stipulation. All right, great. That'll get granted. All right, let's go look for another docket that has a little more information than jurisdictional infirmity, because Hoag Law said, so choice of law wouldn't necessarily settle a federal citizenship question. I don't believe that doesn't make that a winner. That's a very fair point, because I guess they could, well, if they consolidate these in New York, though, they would have to consolidate them in New York. They could still apply California law to it, and they could still have the same attorneys. So if I wonder what she's going to say in the consolidation action. We're going to have to go pull that up too. Because if they consolidate it in New York, I wonder if she's going to, she's essentially arguing personal jurisdiction then, not subject matter jurisdiction, and saying you can't be the boss of me. But again, the contract can still be governed over with the law where she signed it. I guess they're trying to say they don't have authority over her. Let's try to find another document and see what it says. The proposed order is not it. All right. As we do a live research together, let's go see. Docket. Let's take a stroll down the dickety docket. That didn't sound the way I intended it to. That's not how I intended to say it. Damn it. Damn it. But do layers of lawyers have stacks of snacks? Lawyers should always have snacks. They get very grumpy when they don't have snacks. If you have an angry lawyer, feed them. They probably haven't eaten. What the fuck is jurisdictional infirmity? Why do we need to go there? I don't know why they didn't just spell out what the infirmity is. Is it personal or subject matter? What jurisdiction do you have an issue with? Let's see. Minutes of plaintiffs, travelers, commercial issue, insurance company, motion to consolidate. We did that. Declaration in connection with notice and motion to consolidate cases. That's from the 19th. So the only other thing, let's see. Let's see what docket 5 is. The First Amendment complaint. Yeah, we did that. So there's got to be something else that talks about why, and we're going to go find it. Go to Twitter and see. No, let's go to the other case first. Because all we've got in this case so far is jurisdictional infirmity. Your jurisdiction is diseased. It cannot stand. It is infirm. I can't with that language. It's so brilliant in that it literally says nothing about what the issue is. It's like, we have an issue, but we don't want to give you a heads up of the issue. We don't want to tell you what the issue is. What, if any, issues do you have? There's multiple types of jurisdiction. Jeannie says Amber Heard is saying that she's not a U.S. resident anymore and basically that she's homeless. I want to see where that is in which document. That's what I'm trying to find. That's what I've seen on Twitter, but I also want to see how the lawyers say it in the I want to see how the lawyers say it in the document. Renee, thank you. Congratulations on the boost in subscribers, 700K by year's end. We'll see. We're going there. Where are we? Oh, it's 672. Thanks, everybody. Hogue Law, knowing all the things. It's a personal jurisdiction argument. She directs us to 28 USC 1332. I believe. I don't live anywhere. The court only has jurisdiction over cross-state disputes. All right, let's pull the stipulation back up real quick. And not let's pull the stipulation up real quick. Hogue's like, read it more thoroughly and stop making fun of the Dickety Docket. Maybe try that. Maybe try that. All right, let's see. I need to go find the other. Let's see. I need to go find the other complaint then, or it might be in the attached. Let's see. It might be in the attached stipulated ruling that we looked at scantly. Let's go look. No, it's not in there. Hogue, where are you getting the directing us to from? Because it's not in this one. It might be in another document, which is why we're still going down the docket. So, and Miguelina, if you see that answer, because there are like 16,000 of us in here, will you just tag it for me? I feel like we just have all of the lawyers here. So we're going to just find which one. We're doing it together. This is all researching together. You guys are like, Tug read it this morning. Yes, we just have to find which one. So I'm going to go to the other case and see what's filed in the other matter. So this is what's filed in the California matter. There is a jurisdictional infirmity. That's the language that we've got today from this. Let's go to the other docket because there's nothing left on this California docket that we have. So let's see. You need them all live on screen. We'll never get through anything. And I know people are working, so I don't want to impose, but we can always do a co-working session. Maggie's like, control F yourself, Emily. The thing is, we got to find it in the docket. So I think we're done with the California docket. Let me switch over to the New York case and see what's on that docket, because I have not. I told you we were doing a research stream together. And I meant it. And then we're going to Nate's case. So let's see. Let me get back to where I need to be on Pacer and go to the other. There are two dockets. You know what'll be easier for us if they consolidate this is that everything will just be on one docket. We won't have to go to two different cases, which would be nice. Oh, thank you all. Thank you, chat. I'll go get it. I don't know if Amber Heard deleted it on Twitter. Laura B's the real hero. Let me go to Twitter. Thank you, Laura B. We're going to go look at the other docket anyway, but I appreciate that. The umbrella guy here, let's just, before we pull up all the things on Twitter. That's what I'm seeing, that umbrella guy, the umbrella man, umbrella person, unknownst umbrella avatar. I'm making fun of Elaine in that. I know who that umbrella guy is. Says that Amber Heard has deleted their Twitter. Is that in response to an Elon takeover? That's my question. Or is that in response into all of this stuff? So thank you, Real Laura B, who said it's in the minutes. Okay, that's fantastic. Let's go look at the minutes. I can do that. I wonder which case this is. we're going to pull up the docket together just to take a look, because when I said research stream, I got real excited because those of you that have been here a while know that I was a research attorney before I became a district attorney. I very much enjoyed being a research attorney. That umbrella guy's a fellow Tennessean, yes, a much longer resident of Tennessee and has the Tennessee accent down, which is funny because there's times I think when people don't understand what Tug is saying, and I'm like, oh, it sounds like home. I love new home. Let's see. Let's go to the docket report. And let's go take a quick peeky peek through the docket, and then we'll pull up the any of the minutes that we need to pull up. So we'll comb through the docket. This is what you guys get to see. This is what the docket looks like in Pacer on these cases. This is a federal docket. It shows everything that's going on by number, and then you can click on these and pay for it. Anyone can sign up for a Pacer account. It might not help if you don't know what you're reading, but you can. So the minutes are here. Let's just pull those up. Minutes of plaintiff travelers commercial insurance motion to consolidate action filed by travelers. And just a huge shout out to the good work of everyone on Twitter that is literally digging through these. Everyone who's covering like single cases, like Mandy Matney and the way that she is covering through the Murdaugh murders, and the real Laura B and Tug and others that are combing through constantly, Andrea Burkhart, that are constantly combing through the Amber Heard stuff. It helps a channel like mine that does a lot of the consolidation. I cover a lot of cases. We don't get to just do one and go deep. We get to dip in all of the waters over here. But with that, it makes it so much better when I see the kind of subject matter experts diving into their cases going, this is what's going on in this case that I'm following so closely. And that's really, really helpful to me. And I appreciate it so, so much. So let us look at the minutes all together. So thank you, Laura B, for pointing me in the right direction. We're going to view this, and then I'm going to go take a look at what Laura B shared. So let's see. This is plaintiff travelers commercial insurance. The court's tentative ruling was issued October 18th. Court and counsel confer based on the tentative ruling and for reasons stated on the record. Plaintiff's motion is granted. This case is consolidated with New York Marine versus Amber Heard for pretrial purposes only. Interesting. That's a more limited ruling on this. The court sets a scheduling conference for November 3rd at 8:30 with joint scheduling report by noon, October 31st. That's very, very interesting because this isn't necessarily for trial. This is for pretrial purposes, for discovery. And that makes sense because this allows the attorneys who are doing depositions and stuff like that to all be consolidated in one discovery plan, but not necessarily consolidated for trial. Bex, I actually think it makes sense. And it depends on what the attorney said. It depends if one case might settle. And it also depends on if they're going to have to deal with this jurisdictional issue or potential jurisdictional issue with Amber Heard. So let's see what else we've got on the 20th here from this case in this language from the hearing. Let's see. So plaintiff's motion to consolidate. I'm going to look at the other one too, and then look at what, let's see. Look at what Laura B sent me as well, real quick. Because I still don't see. Let's see. This is what minutes of plaintiff travelers consolidated hearing. Yeah, this is what we just went over. Granted for pretrial purposes, the court set the scheduling conference. So let me go and look through the docket just a little bit more with us all together. We've never really done a research stream, and that's really helpful. So let's see. Hogue is sending me things too. I thank you to the research attorneys in the chat. Cheers to all the research attorneys in the chat. This is from, where is this from? This is docket 80 from yesterday. How did I miss that? Oh, because we hadn't gotten there yet. We were working backwards. That's why. Thanks, Hogue. So that's why we were working backwards on the chat. So research attorneys, cheers. Cheers. Way to come through like champions. Let us go through that. So this is the docket. We were working from the bottom. Now we're here. So we started with the minute order, the minutes that the motion was granted. And then we were going to look at the joint scheduling report here. This is where we were getting through, and Hogue just sent it to us to I don't know, spare the chat a research stream. Thanks, Hogue. All right, let's go through this joint scheduling report. We would have gotten there eventually. This is why when people are like, we don't just turn on the camera and stream. No. You get to see all the prep happening in real time. This is what I do normally before I stream, and we're just all doing it together. Forget paralegals. The chat is both Bay and Research Central. Yeah, they are. We should just start calling the chat the research attorneys. We've consulted with our research attorneys. Look, man, the chat can find everything. All right, let's go through this joint scheduling report now that the case is consolidated. I'm sure that the New York Marine attorneys are a little salty about this. So I see questions about my mug. The mods will share the link to get them on Amazon. It's not this exact color, but this was a collab, like a limited collab. I just wonder, yes, Bia, the chat did just get promoted. I wonder if Starbucks is doing another Stanley collab. I would love that, but it's a Stanley mug. I have a link in my Amazon shop to this exact one, but this was a Starbucks collab. There are some different colors if you just get them from Stanley. You don't have to get them from the Amazon link, but you can if you want to. All right, let us move forward. I tell you all, the Lawners are the smartest crew on the internet. Joint scheduling report. Pursuant to the court's October 21st order on Traveler's motion to consolidate, plaintiff and counter defendant Travelers are fucking thrilled. Haha, we won. Blah. Defendant counterclaimant and plaintiff New York Marine in general and defendant Amber Heard have met and conferred, so they've all had a chitty chat. Miss Heard's position. Well, let's see. Ms. Heard respectfully submits that it is premature to enter a scheduling order for two reasons. First, there is no diversity of citizenship. Ms. Kensington, did diversity jurisdiction exist in this case? No, it did not. We've learned this. So for there to be jurisdiction, this is an interesting jurisdictional argument. This is the infirmity. You cannot be in federal court if you do not have diversity. And so let's see why they are arguing there is no diversity. Ms. Heard was not a resident of the United States when New York Marine filed its lawsuit and is not now a resident of the United States. So they're saying as of July, she was not a resident of the United States. Did New York Marine see her scooting out of the country immediately after that ruling? You know why? Because the internet did. The internet immediately was like, oh, she's fled the country. Immediately. The internet immediately did. I wonder if this is pure, rampant, galloping speculation. Take all pure, rampant, galloping fucking speculation with a grain of salt. I wonder if she deleted her Twitter because there might have been things on the Twitter that belied that she was completely out of the country this whole time. You guys are saying, but she owns a house. She sold her house. The chat probably knows the date of when she sold the house, but she sold the house. So she sold the house. Therefore, this court lacks jurisdiction. She doesn't even go here, Your Honor. She's fled the country. They are trying to argue that she is domiciled in the U.S. I don't know if she's using a U.S. passport or not. This is going to take time for them to sort out. It's going to take time for them to sort out. Question, I don't think residency works like that. Doesn't it take 8 to 12 months to be considered domiciled somewhere? I'm going to have to look, well, we're probably going to get some arguments in this court, but I'll be very, very interested to see. She sold the house in July. The lawsuit was filed July 8th. She signed over her house July 18th. The chat knows things, but she probably still is, but she's not a resident. So y'all who just pop a emoji, pop a heart emoji in the chat if you remember the Toddy Westbrook case when we talked about the difference between residence and domicile and owning a home and where you're domiciled and where you have jurisdiction and where you don't have jurisdiction. We've gone over this and it actually can be complex as to where the court has jurisdiction. So for all of you that remember the lengths we went to talking about domicile, because there was a lawsuit going on while Toddy Westbrook was domiciled in Washington, but they had a residence in California. And they're like, we're not domiciled in California. You can't personally sue us here. Let's continue on with this. This is the meat and potatoes. Thank you, everyone who got us to this. Therefore, this court lacks jurisdiction because the defendant is a U.S. citizen, but has no domicile in any state. She is stateless for purposes of 28 U.S.C. 1332A3. Such a stateless status destroys complete diversity under 1332A3. Cleaned up quoting Newman Green Inc. versus Alfonso. We're going to have to do legal research. But the interesting argument is that you destroy diversity jurisdiction if you have parties that are from the same state. So they're saying she could be anywhere. She's stateless. So if she domiciles in New York, it destroys complete diversity. So you can't have diversity jurisdiction because it could be anything. Could be lunch meat, could be peaches, it could be anything. Oh, this is clever. It's clever. I don't know how well it will work, but it's clever. So they're not arguing she's not a U.S. citizen. They're saying she's a U.S. citizen, but she's not domiciled anywhere. And because of that, they don't have diversity jurisdiction. It's a very, very interesting argument. I have never seen anyone argue this. I mean, I'm sure it's happened. Oh, we're going to have to do a whole podcast on this. That's what we're going to have to do. This is a first look. We're going to have to do a whole podcast and I'll read the case and we'll do some legal research. What do we think? Chat, put a 1. Oh, let's put up a poll. Miguelina, will you put up a poll and ask if this is the podcast? What is he doing out there with that thing? My husband's just like outside the window, swinging it around, trimming the bushes. We don't have a Manscaped commercial today, my guy. Anyway, let's put up a poll and see if we want to do a deeper dive on this for next week's podcast. Let's see. Yes or no. We'll do that. All right. Second, this litigation should not go forward at this time. The continued prosecution of these actions is prejudicial to Ms. Heard's defense in the Depp v. Heard lawsuit, which is currently pending appeal. How, though? But why, though? But why, though? But why, though? But why, though? Y'all are making fun of my phrasing. It's true. He has the giant, bushwhacker out there. It's huge. It has teeth. I don't even know. Chaos. We're having chaos today. We're having chaos. All the chaos. I don't know how this is prejudicial to the defense unless it's just about who's paying for it. I guess that could be damaging, but not prejudicial. Ms. Heard understands that Travelers does not oppose the request for a stay of the consolidated action. Of course they don't. Travelers is going to do whatever the fuck you want. That's clear. That's clear. Travelers is like, we've got it. Whatever, babe. Travelers is just like, we cool. New York Marine is like, what the fuck is happening here? And Travelers is like, it's all good, babes. Oh, Travelers. Oh, Travelers. Ms. Heard understands that Travelers does not oppose the request for a stay of the consolidated action and that New York Marine does not oppose a stay as to 3 of its 4 causes of action. The court opposes it. They asked the court to stay these proceedings when the trial was pending, and the court was like, no, I don't care what's happening in Depp v. Heard. We're not staying this action. However, Ms. Heard let's make this bigger. However, Ms. Heard understands that New York Marine opposes a stay as to the first cause of action as to the claims at issue in the Travelers lawsuit. Therefore, as she has advised the other parties, Heard will file a motion to stay or dismiss these actions pursuant to Montrose Chemical Corp v. Superior Court, California case, and its progeny. In addition, Ms. Heard intends to move for judgment on the pleadings as to each of New York Marine's causes of actions against her. Oh, litigation. We're getting more litigation. They're going to move to dismiss for lack of jurisdiction before they answer. Well, that makes sense why they wanted time to answer. They put over time to answer so they can make all this. So this is going to go down. She put over her time to answer at the end of November. So I said yesterday on a meeting with my team that I was traveling in November and it's Thanksgiving. And I was like, November will probably just be quiet, right? And Dan, my incredible podcast editor, said, why the fuck would you even say that? It's never quiet. You know you're traveling. Just don't speak it. It's never quiet. And here's what I'm seeing right now, that we have motions for judgment on the pleadings. We've got motions regarding jurisdiction, and the actual body of the appeals are going to drop this month. November is going to be swathed in litigation, and we have sentencing on Sunny Balwani, on Elizabeth Holmes, on Daryl Brooks. November is chalking up to be a very, very busy month. I think this is what. Yeah, and there's a whole fucking election. If by the way, if you live in Los Angeles County, Barron for judge. She's one of my very, very dear friends, but is great. I get on a plane on Monday. What the fuck is going to happen? All right, we've got time. But we've got next week's podcast, I think, is what we're going to be doing. Don't forget to go vote in the poll. And we're going to stop saying quiet ever. Love the wording on the poll. Should we deeper dive? Yes. Should we? I think that's what I said. Probably exactly. Oh, gosh. There's not enough coffee for this. We're going to get back to law school. We're just going to get back to law school. We're just going to go back to, I'm going to have to clip that diversity jurisdiction video clip from Legally Blonde and just load it up into the stream. We're just going to have to play it over and over and over again. We're going to go back to law school. Look at us. We're going to just do a whole class in jurisdiction this month, which feels parodied with 2 years ago talking about jurisdiction in the Toddy Westbrook case. Look how far we've come, but really moved nowhere at all. We're circled right back around to a different aspect of jurisdiction. My, oh my. In addition, Ms. Heard intends to move for judgment on the pleadings as to each of New York Marine's causes of action against her. New York Marine's first, second, and fourth causes of action, which address New York Marine's duty to indemnify a judgment in the DEP lawsuit, are not ripe until there's a final judgment in the DEP lawsuit. Actually, they filed, oh, that's right, in the Jen Shaw sentencing. They filed the final judgment. I guess they're saying we need a final judgment after appeal. Given the appeal, there is no such final judgment. New York Marine's third cause of action addressing New York Marine's duty to defend Ms. Heard in the DEP lawsuit fails as a matter of law because the statute relied on, California Insurance Code 533, does not excuse an insurer of its duty to defend. Despite the above, New York Marine will not argue to postpone depositions of Heard's former defense counsel, Elaine, in the DEP lawsuit noticed for mid-November in the Travelers lawsuit. Ms. Heard believes that discovery should not proceed pending the court's determination on the jurisdictional issue as to whether the consolidated action should go forward, given the appropriateness of dismiss or stay under Montrose. If necessary, Heard may move for a protective order regarding these depositions. I imagine that'll happen. New York Marine's position. Personal jurisdiction over Heard. New York Marine has received no evidence establishing that Heard was not a resident of the United States at the time New York Marine filed its complaint against Ms. Heard. Prove it, though. Prove it, though. Prove that you weren't a resident of the U.S., and I think selling the house might come too late. I think selling the house really might come too late. Ms. Heard's request to stay the insurance litigation. New York Marine understands that Heard intends to file a motion to stay and will not oppose a stay as to the second, third, and fourth causes of action. This is going to go on for forever. Hoke's just in his little research attorney world out here. 28 USC 1603, a foreign state is neither a citizen of a state of the United States nor created under the laws of any third country. They have jurisdiction over such a thing. So I don't know if they're going to get diversity jurisdiction destroyed, but it's a curious and kind of fun argument, isn't it? I think so. Let's see. However, New York Marine's first cause of action is ripe as there is an existing judgment against Ms. Heard. That's fair. And this would be my argument. There is no stay in the collection of it because she did not post the suspension bond to stay collection. If she had posted a suspension bond, I could see the argument that collection should be stayed. So that. Lisa Fink said diversity jurisdiction exists when two conditions are met. First, the amount in controversy must exceed 7,500. We got that. Second, all plaintiffs must be different citizenship than all defendants. And she's arguing essentially, well, you don't know where I live. So it could be here, it could be there. That's her argument. We'll see. We'll see. All right. Temporary halt to scheduled depositions on September 3rd, 2022. Counsel for all parties agreed to continue. He's right outside that window. Agreed to continue previously scheduled depositions, provided that the depositions were moved to a date certain, and those depositions were set for mid-November based on the availability of deponents and counsel for all parties. At no point during the rescheduling was there any indication of that jurisdictional questions would be raised. You would think that would be literally the first fucking thing that you would say. They're throwing spaghetti at the wall, I think, with this one. It feels like a spaghetti throw. It feels like just hurl it and see. Accordingly, New York Marine believes it's appropriate for the deposition scheduled to move forward. Traveler's position, personal jurisdiction over Ms. Heard. This issue just arose. Either you were a resident in July or you were not. That's all. That's all. Rob, y'all are reminding me of how much I hate Civ Pro. Just so much frustration. It is. It's interesting, though. These are interesting arguments because I'm not the lawyer that has to litigate it. I just get to talk to y'all about it. We still have another lawsuit to get through. Travelers does not have adequate information to take a position. They don't want to say we don't know. They don't want to say we don't know, but that's because Travelers has been very much aligned with Amber Heard's side. New York Marine is like, prove it then. Travelers is like, we just don't have enough information, which means they're on her side, but they're also being honest. That's what I don't have enough information to take a position means. It's, I want to be on your side, but I have to be honest. And so this is kind of the neutral middle ground of we need more information to decide what we're going to say because they want to stay on her side. Ms. Heard's request to stay this insurance litigation. Ms. Heard asserts that she will be prejudiced by this consolidated insurance litigation proceeding while the DEP lawsuit is active. It's going to be fucking active. Travelers will not oppose her request for a stay on that basis. Travelers understands that New York Marine will argue that it should be able to proceed with part of its case. Travelers strongly opposes a partial stay of the insurance litigation. They have to get things done. I don't know if this judge is going to be inclined. This judge wouldn't stay the case when the trial was pending. I don't think the judge is going to stay the case now. I don't. They are strongly opposed to a partial stay of the insurance litigation, allowing New York Marine to move forward in part as it wishes. This would be prejudicial to Travelers and Ms. Heard. Well, let her argue that then. Stop arguing for her. And it would be highly inefficient. It likely will drive all the parties into discovery disputes, which can be avoided by a complete stay. The discovery needs to start. Start discovery. Stop waiting. If the court stays the insurance litigation while the DEP lawsuit is pending, it should stay all of it. Temporary halt to scheduled depositions. Ms. Heard has asked that the parties agree to postpone 2 scheduled depositions until the court has ruled on the request for stay, and Travelers has no objection. Of course you don't. They're cooperating with you. And then these are requests for new discovery dates into 2023. Well, that was fruitful and interesting. Let's end the poll. Are we going to have to do a deep dive? I think we need to do some actual law on this. This is very interesting. Hogue has done all the law in the chat, and so has Rob. I've seen y'all lawing in the chat. Thank you to the chat. Chat is Bay, research attorneys. This was really interesting. I am not a U.S. resident. I am international, baby. That's the argument here. Should we deeper dive on this in the podcast? Yes, 90%, no, 9% with 3,000 votes. Y'all, there are like literally 17,000 of you here. I guess y'all wanted to do it. So don't forget to do the YouTube things. We're going to move on to a lawsuit that I'm apparently mentioned in, but this is going to be really, really interesting. Law and Lumber said, I would love to see them try to pull this in Virginia. Let's see. Rocket Docket would have been like, cut the effery and move on and get moving, trial in 2 months, go. This, I mean, I don't think the federal judge is going to be inclined to give them a complete stay. The judge hasn't been inclined to do that at all. So we will see. All right. We are going to move on to the Nate lawsuit. Let me just pull up the documents because this was going to be our only topic today. And now it's not our only topic today. So let me just make sure those documents are pulled up because it's filed in my YouTuber lawsuits. The YouTuber lawsuits have become a whole like subsection of content here on the channel, but we also have an article from Law 360. So we're going to do both. We're going to go through the Law 360 article that was published yesterday at 3:30. And then we're going to, I think I was still streaming then. And then we're going to go through the Bouzy lawsuit. So are you ready? Are you ready? That was wild. All right, it's time to swoopity swoop. Let's go. First look. This is a first look. I have not looked at this lawsuit. We need to be prepared. We are preparing. We are preparing for a first look. Oh, my light didn't light. We'll have to wiggle it. There we go. This is a new tube of gloss. All right. Law nerds, we are moving on to Nate the Lawyer versus Bouzy. All right, let's go to this article from Law 360. Y'all know I love their reporting. Attorney YouTuber launches defamation suit over online claims. October 31st, 3:35. A New York attorney who runs the Nate the Lawyer YouTube channel. See how they just wrote it? A New York attorney. You know what they didn't say? Attorney. New York attorney. That's what they didn't say. Sorry. The shade that gets thrown at all the lawyers who deign to be content creators. Lawyer. That's not how that works. Still a lawyer, can be both. varying levels of success, but can be both. So, a New York attorney who runs the Nate the Lawyer YouTube channel has launched a defamation lawsuit in New Jersey state court against the man behind a platform that purportedly tracks disinformation online. Purportedly is a good use of word here. Accusing him of spreading lies about the lawyer on Twitter. Plaintiff Nathaniel Brody, Nate the Lawyer, whose channel has more than 250,000 subs, alleged Friday that Garden State resident Christopher E. Bouzy of Balt Sentinel, we'll just call him Bouzy. I bet you half this chat is blocked by this man on Twitter. It seems that he went through the people who follow like me and Nate and some of the others that are legal content creators and just blocked fucking all of them. People are like, I have never even heard of this man and I'm blocked. Yeah, I never said anything about him directly at all. I said once, when somebody starts calling a lawyer, you know you're going to start getting into the personal attacks part of a conversation. And that's exactly what happened. He started personally attacking Nate in a really, really ugly way on Twitter. And Nate was like, fuck this shit. I'm not, what you're not going to do is lie on my name. And now we're here. I'm sure all of you watch this, but look at this chat. Should we put up a poll? Let's put up a poll. Yes, I agree. Let's put up a poll. Let's put up, Oh my God, look at how many of you. Um, and you know, some of it started, we do need a poll. Are you blocked by Bouzy? We'll put it up. We do need a poll. This is wild. Because a lot of you have probably never said anything. There is a function, it seems, within his website where you can actually just like go to an account like mine or Hoax and block everyone that follows that account, which in my case is over like 180,000 people. So I'm sorry if you're blocked. That's wild to me. But so many of you are like blocked, 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 blocked. I see the chat has just blown up. I'm really curious to see how many votes we get in this poll. So thank you for putting up a poll, Miguelina. I'll leave this up while we cover this lawsuit. Some of you are like, I never even log into Twitter and I'm blocked. It's because he's going through all of the follower lists, which creates an echo chamber. So when he does things like attack Nate, um, it's only people he's allowed to enter the conversation. I mean, at least when others do that, someone like a Taylor Lorenz, she will turn off comments and you can see that comments are turned off or limited to people that she follows back. While I don't love reporters not allowing comments, I also have seen her getting horrible comments of like violence being wished against her. So at least I feel like there's an honesty to showing someone that you are turning off comments. Like comments are off. So people know. And then what they do with an account like Lorenz's is they will just quote tweet her and make whatever comment they were going to make in the comments. It at least has a level of transparency. Bouzy creates an echo chamber by blocking people en masse and then making it seem like everyone just agrees with him instead of just saying that comments are limited. His comments are limited because he's blocked half of the motherfucking internet. I should give a disclaimer as I talk about this lawsuit. I like Nate the lawyer quite a lot. There is a clip that they used against Nate online. I was on a stream with him when we were having a conversation. I'm sure that's going to come up and we'll talk about it. I have not interacted with Christopher Bouzy. He blocked me on Twitter. I don't really care. I hate the way that he has personally attacked Nate and others. I do not like it. So when covering this lawsuit, I like Nate. I don't like the way Bouzy engages. So everything I say is through the lens of I very much like Nate. Though I will say, if there are claims that I don't think are strong, I will tell you that. But this is coming through the lens of I like Nate. I consider Nate to be a friend. I like the way he engages. I think Nate has a tremendous amount of integrity, and Nate is fearless. When Bouzy started coming at him, he was like, then let's go then, because this is not what you're going to do. Nate leveraged attacks against Bouzy too. Others did too, but Bouzy came with the personal attacks quickly. So we are going to go through this. I just wanted to give that caveat. I think all of you know that Nate and I have streamed together. We've interacted together. I like the way he breaks things down. I like the way he creates content. So on this, I am inclined towards Nate from the beginning, and I watched all this go down when it happened. So let's see. We will just take a look at this, but that is the disclaimer when we get into this, is that I'm not going in neutral on this. Bouzy also factored heavily into the Amber Heard case. He was, I think, hired by the Amber Heard legal team early on in the proceedings to look at disinformation online and try to determine what bot accounts are doing what. But Bouzy is the one training the algorithm about what's good and bad. And we saw this come up in the testimony in Depp v. Heard. This ends up being a very Depp v. Heard day unintentionally. We saw this come up in Depp v. Heard when the analyst was saying, well, I took every tweet that had these hashtags as against Amber Heard. Well, how can you decide what's against Amber Heard from a hashtag? Hashtag justice for Johnny Depp isn't necessarily negative to Amber Heard, because there could be tweets that say things like, what the fuck is with justice for Johnny Depp? Johnny Depp is a this or this or that. So you can't just say everything in this hashtag is negative to this person. And that was the kind of thing we saw in Depp v. Heard that Runkle has pointed out. I think Hogue has pointed these things out on Twitter, which earns them all blockety block blocks. So let us get into this with all of those caveats put out there. When I know people in these lawsuits, I'm going to always tell you about it. So, but the benefit of being a lawyer is you get to say, look, this is where I'm inclined, but we're still going to look at the law of the thing. You guys, the chat, I will let you know, I am living for how many of you are stunned that you're blocked. I'm living. I am absolutely living for all of you that are like, what the fuck? I know. I'm sure for some of you, this is the first time you've ever been blocked by anyone on Twitter because you just don't engage that much. So, alrighty. Thank you, chat, for having a conversation and still adhering to the rules. All right. With over 18,000 of you here, hey, just go ahead and do the YouTube things and the likey, subscribey things. Yeah, this is it. Some of you are like surprisingly not blocked. All right, let's continue on. Oh, we should have put a third option. Don't have Twitter, but it's okay. You can abstain from voting. Hogue said, Rob and speeding. He attacked Joe. He attacked Ian. He attacked Nate. Yeah, he did. And his racialism was abhorrent. He went after Nate about Nate's family, about how Nate grew up. We'll get into it. Let's get to the lawsuit. Instead of rehashing. I'll let Hogue and Rob rehash what he went after people about. He didn't like it when they went through his bankruptcies. There is so much drama. This is just, it's drama. It's drama. Let us go. All right. Oh, wrong way. Plaintiff Nate the lawyer, whose channel has more than 250 subscribers, alleged Friday that the Garden State resident Bouzy of Bot Sentinel tweeted various false claims about him in recent weeks, including that Nate is not a lawyer and that he planted evidence on suspects when he served as a university police officer. He said that the false claims misrepresent Brody's veracity, trustworthiness, and qualifications. I think this goes to defamation per se. We'll see what the lawsuit says. To act as both a lawyer and legal commentator, according to the complaint, Bouzy, quote, made and published the false statements alleged above, knowing they were false or with a reckless disregard for the truth. Because it's easy to find that Nate is a lawyer. And when somebody said, it took me not very much time to verify that this individual is actually licensed in New York, Bouzy was like, I wasn't gonna say that. I was gonna see who could find it, indicating that he fucking knew on Twitter, indicating that he knew. Mr. Brody has been, and if the harm done to him is not remedied, will continue to be damaged by the defendant's conduct, including by reason of harm to his reputation, loss of income, and other harm in the amount to be determined at trial. Yet he alleged that Nate planted evidence on people as a university police officer. According to Bot Sentinel's website, Bouzy launched the platform to help fight disinformation and targeted harassment. We publicly displayed detailed information about Twitter accounts the platform is tracking to give visitors of the website a better understanding of how nefarious accounts spread disinformation and target other accounts. They rank you. They give ratings. And the ratings are determined by the way Bouzy has trained the algorithm. So, okay. Bot Sentinel uses machine learning and artificial intelligence to rate Twitter accounts on a score of 0 to 100, the website says. The higher the score, the more likely the account engages in targeted harassment, toxic trolling, or uses deceptive tactics engineered to cause divisive division and chaos. How does one determine any of those word salads? Targeted harassment. How do you determine targeted harassment? Toxic trolling and deceptive tactics. Deceptive tactics being the most vague. Deceptive tactics engineered to cause division. How do you determine that? What does that even mean? Nate the lawyer's complaint disputed such technological claims and alleged that Bouzy has learned how to employ catchphrases, techno gobbledygooks. Oh, this is going to be fun. Techno gobbledygook and sleight of hand and a healthy dose of crowdfunding to throw up cyber smokescreens festooned with enough bells and whistles to enchant the unethical and uncurious. Ouch. I mean, this lawsuit's going to read a bitch, isn't it? All right. This was and is Bot Sentinel, the complaint says. Bot Sentinel was previously hired by Amber Heard's legal team to examine social media activity against the actress, who went up against Johnny Depp in a high-profile defamation trial this year. And disappointingly, when Rolling Stone talked about Bot Sentinel, they did not disclose that fact until it was pointed out to them. Disappointing. Following a verdict largely in Depp's favor, Bot Sentinel issued a July report regarding platform manipulation. This report was a mess. Ian Runkle of the Bailey has a fantastic thread about why this report is a mess. A fantastic thread. Regarding platform manipulation on Twitter with respect to criticism of Heard, the report, which said it was not paid for by Heard or anyone from her legal team, received media coverage. And then the report updated itself. Didn't it? Didn't it? In Nate the lawyer's complaint, he asserted that Bouzy began going after him in September after he and other so-called lawtubers, there we go, there, put the quotes around lawtubers. Lawtube is a genre. It's a genre. It's not a thing. We just all also happen to be lawyers at stream. It's a genre. It's a genre. Wait, did Law 360 accurately report the Depp v. Heard verdict accurately and without bias? What did I just read here? Yeah, I love Law 360. A lot of their writers are lawyers. They do good work. It's a genre. Sorry, I spent too much time on TikTok lately. Brody and other so-called lawtubers. That's where we can put the quotes. Lawtube. Had taken, quote, to sharing critical takes of the widely reported Bot Sentinel claims of widespread troll bot activity engaged in a coordinated social media attack on Heard. Look, the Heard folks coordinated attacks on everybody else. There were a lot of attacks happening. It wasn't just directed at Heard. Among the purported false statement, Bouzy attacked Brody's veracity and professional qualifications. For example, on September 17th, Bouzy allegedly stated in part, "I can't tell if this guy is a legit lawyer or just a social media lawyer." Do you mean a lawyer on social media, or do you mean like playing one on TV? Bouzy later conceded the falsity of his claims about plaintiff's background and credentials, but went on to accuse Nate the lawyer in a September 18th tweet of being a Twitter troll and grifter. I don't know if that's defamatory. Bouzy, whose Twitter account allegedly gained followers as he attacked Nate and others, sought to keep the pot boiling and played the trump card of social media engagement, the race card, the complaint says. Nate and Bouzy, by the way, both black men. Oh, Hogue said Ian also came in for Hangouts and headlines the day of the report. If you want to watch us deep dive through the terrible, evidentless Bouzy BS. I love the way Hogue does Hangouts and headlines. Hogue, will you just DM me a link so we can add it in the description of the video? Thanks. Appreciate it. That's the wrong button. And then we'll add it so you guys have a link to Hogue's video breaking this down, because I did not break it down. Referring to a series of complaints on September 21st, the complaint stated that according to Bouzy, Mr. Body, an African-American, was jealous of the success that he, Bouzy, had achieved, and his criticism of Bouzy and his businesses were motivated by nothing more or less than a desire to fit in with his Caucasian peers. In late September, Bouzy also falsely tweeted that Nate the lawyer had admitted in a video to, quote, the planting of evidence on innocent criminal suspects. The complaint included purported screenshots of a series of Bouzy's tweets about the allegation on September 20th. Bouzy, quote, was so pleased with what he evidently believed was the perfect social media massacre of Nate the lawyer that he paid no heed to comments from other users questioning his take of what Nate the lawyer was, quote unquote, admitting in the video and suggesting that Bouzy's claims did not stand up to a complete and reasonable viewing. Nate's lawyer, Ron Coleman of the Dillon Law Group. The Dillon Law Group, by the way, you can follow Ron Coleman on social media, on Twitter. I believe he also has a YouTube channel. His law firm is also representing Adriana Jacob in her lawsuit against the New York Times and against Taylor Lorenz for defamation. This is a law firm that does this. Coleman told Law 360 on Monday in a statement, over 250,000 people subscribe to Nate the Lawyer's YouTube channel to hear Nate explain the law with honesty, grit, and joy. Nate has seen it all and tells it like it is. Nate has a great perspective. He has a great perspective. He's worked as a cop. He's worked as a prosecutor. He's worked in law schools. Nate has a great way of breaking things down. And he's like, you be the judge or you be the jury, really. But if what he says upsets someone or someone's client, that doesn't make it okay to malign him and ruin his livelihood. Ron Coleman, what the fuck are you saying? If you disagree with someone, the thing you don't do is try to destroy them on social media? What kind of civilized society do you think we're living in? Because that seems to be the playbook of anyone who disagrees anymore. Not the law nerds. Not us. But this is the playbook. I don't like what you said, therefore I will try to silence you across every fucking platform I can get to listen. It's appalling. But Ron's like, oh, that's not okay. Radical statements, Ron Coleman. But if what he says upsets someone or someone's client, that doesn't make it okay to malign him and ruin his livelihood. And the thing about Nate is that Nate is so in the middle, he upsets everybody. Everybody gets mad at some point. Everyone gets mad at some point because Nate's like, no, I'm in the middle. Sometimes I say this and people who are more to the right of me are pissed. And sometimes I say this and people who are more to the left of me are pissed. People are always pissed all the time because he's like, I just call it like I see it. That's what this lawsuit is about. And that's why this lawsuit is important. It doesn't look like there is a statement from Bouzy or Bouzy's lawyer, but you know what we have? We have the complaint. So let's get into it. We should swoop now that we're doing the complaint. Complaint! Haha. This is why we started today at Code Red. Don't forget to vote in the poll and let us know if you've been blocked by Bouzy. You'll learn his handle in just a second here. All right. This is filed October 28th. We are in Jersey. What up, Jersey? What up, Jersey? The parties. I'm going to call Nate the Lawyer forever because the more we call him Nate the Lawyer, the more people go check out his channel. And that's the best way to support him as he's going through this. Nate the Lawyer. Nate the Lawyer is a former university police officer of the city of New York and a member of the New York Bar, a former Bronx County Assistant District Attorney. In Los Angeles, they're deputies. In New York, they're assistants. And former law school instructor who created and operates a YouTube channel under the name Nate the Lawyer, which can be found at good job linking the channel. Like, good job linking the channel. Ron Coleman knows. The purpose of Nate the Lawyer's channel is to make the law more accessible to people. Since its founding in 2014, the Nate the Lawyer channel has collected over 27.6 million views. It is currently approximately 255,000 subscribers. Defendant Bouzy is a serial... They're just coming in hot. This is the resume portion of the lawsuit where you're allowed to frame the issues. Lawsuits are allegations and shade. That is what it is. Lawsuits are allegations and shade. They are just starting with the shade. We'll get to the allegations in a minute. They're starting with the shade. They're starting with the shade. Bouzy is a serial failed entrepreneur and, in the opinion of many, a serial successful swindler. Here's the thing about lawsuits. Litigation privilege. You can't really sue someone for what they say about you in a lawsuit. You have to prove it in court, but lawsuits are allegations and shade, and we are just getting started. Bouzy is a resident of North Bergen. They have a great DCI band in Bergen, the Knights of Bergen County. Anyway, having an address at, we don't want public documents. I hope that's a business address. We're going to keep moving. The court has jurisdiction over this action because the defendant is a resident of the state of New Jersey. They just went to where he lives. Facts applicable to all claims, live streaming, and there's the quotes, LawTube. Genre. It's a genre. It's a genre. You guys, The fact that is it the cadets? I thought it was the Knights of Bergen County. Is it the cadets of Bergen County? I could have been wrong. The chat will correct because chat is Bay and we've got our fair portion. We've got our fair portion of band geeks in here. I love watching you guys still come to the realization that you're blocked by Bouzy. I love it. I love it so much. I love seeing the constant flow of comments as you realize you're blocked by Bouzy. It's life-giving. Sorry, cadets of Bergen County. Cadets. Apologies. Did they move to Pennsylvania? I didn't know. Okay, let's keep going. Live streaming in LawTube. The Nate the Lawyer channel is best known for its live streams on video and videos on demand, VODs, which are transmissions of video and audio over the internet by channel hosts who attract viewers to their programs by virtue of expertise, personality. We go with personality first up in here, and then expertise, guest selection, or other qualities. The channel focuses on both pre-recorded produced videos and real-time live streaming coverage of events of widespread interest and increasingly popular form of live streaming. One attraction of live streaming is that it allows viewers to participate in the program through messages and interactions sent through screen chats. Hello, messages and interactions sent through screen chats. I love the meta nature of getting to do this. I love it. This running commentary is visible to all participants in a chat window shown next to the window on a viewer's computer screen or mobile device, to be fair. A super chat is a paid message that, in exchange for payment by the viewer, makes the viewer's chat comment more colorful and eye-catching. They are colorful and eye-catching. They are. I saw somebody earlier send some Bouzy bucks, which became a joke when this all started, that Nate was getting super chats for the Bouzy bucks. He went after Rob too. That's right. He went after Rob. How dare Rob drive fast sometimes? How dare he? A super chat is a paid message that, in exchange for payment by the viewer, makes the viewer's chat comment more colorful and eye-catching and more likely to be responded to by the live stream host than ordinary comments. While new comments in the chat stream displace older comments, super chats are special and rise to the top of the chat window. The purchase amount determines the duration of the pinned comment. For a $5 payment, a super chat comment stays stuck on screen for 2 minutes. I never knew this. I'm fast. I never knew the amounts of time. Truly. We learn something new every day. Larger amounts stay visible longer. For less than $5, a comment still stands out but disappears as usual. Popular live streamers are able to generate significant income through super chats as well as other monetization mechanisms offered by YouTube. Through his work, Nate the Lawyer's channel, Plaintiff is part of an informal group of experienced lawyers. There's no group. We just do the same shit. An informal group of experienced lawyers with law-oriented YouTube channels who live stream, often as a group appearing on one channel, legal commentary and discussion, often referred to as LawTube. I just have to put on, for the record, I'm adding a gavel. But for the record, the reason I pushed so hard to call it LawTube was because it visibly irritated the fuck out of Nick Rekieta. He was like, that's horrible. And I was like, yes, we're going to make it happen. Just like Wood Daddy Stacks. It was a joke when we were all on a stream together, I think during Rittenhouse, and it was like, what is this group of lawyers? And we were joking about it being like an invoice of lawyers or like a murder of lawyers. But I watch BookTube and Book Talk and BeautyTube and all of the different areas of YouTube that kind of take what they do and add it to tube. And I was like, it's LawTube. And he's like, what? That's awful. I'm like, yes, LawTube. And that stream, when we were talking about murder of lawyers and invoice of lawyers and all the thing, is where LawTube started, with me saying, no, we're LawTube. Like BookTube, it's LawTube. And he's like, this isn't a thing. I hate this idea. I hate it so much. And I'm like, I thought it was funny that it annoyed him. That's all. I thought it was funny that it annoyed him. I thought it was hilarious. So then I started saying, no, it's LawTube, because I thought it was fucking hilarious, but it was always meant to just be a genre of LawTube. So somewhere that stream exists of us having that conversation and me trying to make fetch happen and everyone else being like, Fetch isn't going to happen. And me being me going, oh no, LawTube's catchy. It's great. This is what we do. We stream law. We're all lawyers. We are the world of LawTube. And Nick going, God, I hate that. I hate that. I don't want to organize a thing. There's no thing. And I was like, what do you call everybody? What do you call? There's so many lawyers that do what we do. What do you call them all? So LawTube became the genre. And I thought it was funny. So that's how the genre got named. And we made Fetch happen. Sometimes you cannot do anything but get out of the way of Emily's will because it will happen. Ask my husband when he was like, what we don't need to do is buy a new car. You can't get out of the way of my ADHD hyperfixation fucking fast enough. The will of the people has spoken. LawTube became a thing. But it's on that stream somewhere. We're going to have to go find it. It was on a Rittenhouse trial stream. It was. I just don't remember where, but that's where it was. And so, again, I thought it was funny just because Nick and Viva were the top subscribed to streamers going into the Rittenhouse case. They had the biggest channel. Nick was like, I'm streaming every single second of this trial. I will open my channel to anyone who wants to join. You're welcome to come in, have conversation, watch the trial with me, but I am here every single day. This is what I am doing. And opened his channel up and let people join and come in and out as they had time. And those streams grew massively. And then YouTube yeeted the stream one day. If I remember correctly, it's because of Law and Crime that they yeeted the stream. But they yeeted the stream, and then Nick ended up on the news about YouTube shutting down the stream. There were over 100,000 people on Nick's stream, watching, and shut down the stream. And it became a news story that coverage of the trial seemingly was getting yeeted from YouTube or blocked by Law and Crime, one of the two. And so it was real interesting to see how that all grew. And then Nick's channel continued to take off. Others that streamed were found through that. Some people came and subscribed to other channels of the lawyers that they liked. Some didn't, fine. But we had these conversations during the downtime when we were joking about, what is this thing? Because I love naming a thing. I come from the entrepreneur space. We love to name a thing. And that is kind of how that started, with everybody just having a conversation, meeting each other and chatting. And again, I enjoy some friendly banter, and annoying someone over the name LawTube is friendly banter. That's lawyer banter. We can all agree to disagree. The members of YouTube are highly diverse in terms of seniority, legal speciality, political viewpoint, race, religion, and sex. True. As described in a May 26, 2022 article in the Los Angeles Times, live streams of sensational trials accessible to in-court cameras, such as the November 2021 criminal trial of Kyle Rittenhouse, have become a new and arguably dominant way for internet users to watch these live trials. Right, because we add value and help people understand the trials. Yes, Dr. B, I was ranting about a lawsuit that I'm apparently mentioned in.
Always hate to interrupt your rant.
Yes, I see the time. Thank you. Dr. B's like, Emily, you can't just stream forever. I know. As a result, and describe, wait, is this my LA Times article? I know Hogue covered it too. I'm wondering if it's that LA Times article. As a result, and as described in the same article, such live streams represent important opportunities for LawTube streamers to realize significant growth in their subscribership, viewership, and engagement measures. These in turn have the potential to increase the prominence of a given streamer's channel, that's facts, such as through enhanced search results as well as generate revenue and just enhance visibility. Richard asked, is Legal Eagle part of LawTube? Here's why I haven't considered Legal Eagle part of LawTube. He doesn't stream. And anyone can have a different definition because genre, I always saw LawTube as streamers, and Legal Eagle does not stream. He's a lawyer that creates content on YouTube, but I've never seen him stream. So I always considered it to be streamers, but I see myself as a streamer first. So live streams by LawTubers and other live streamers depend on their popularity in large part on how potential viewers perceive the host's experience, professional knowledge, and above all, credibility and personality. And personality and personality and personality. The Johnny Depp Amber Heard trial. Let's get into it. Following the success of LawTuber's coverage of the Rittenhouse trial, the group coalesced around coverage of the sensational defamation trial that pitted movie star Johnny Depp against former wife, actress Amber Heard. Depp's defamation claim was based on her publication on the Washington Post opinion page of claims that she was physically and sexually abused by Depp. Depp prevailed at trial. As the case ramped up towards a verdict, however, a celebrity-obsessed public was riveted by the scandalous nature of the claims by such high-profile entertainers, combined with the normal strong appetite for legal drama. People love a legal drama. People love a legal drama. To some extent, however, public sentiment concerning the case divided along political and cultural lines because Heard's claims represented a high point in sway of the hashtag #MeToo movement. I saw this case dividing on cultural lines. Just from my personal chats, I saw so many people say that they had diversely political leanings and were still all on this stream saying, I just can't believe what she's saying, because it's not believable. Let's see. Because Heard's claims represented a high point in the sway of the hashtag #MeToo movement, a social trend that focused attention on the widespread abuse of women by men in positions of power and influence, especially in the entertainment field. I think that's a really fair recitation of the #MeToo movement. Indeed, the trial was described by many commentators as a tipping point in the battle between extreme poles that had formed around the #MeToo movement. I mean, some. The Washington Post, for example, printed a column in June stating Dixon was alarmed by the giddy derision that seemed to follow Heard. In particular, she had hoped to avoid the trial altogether, but when her 17-year-old daughter showed her a pro-Depp meme despite not knowing much about him prior to trial, Dixon realized how much it had permeated popular culture. The live-streamed trial was widely followed by observers online. Yep. And social media was overwhelmed by Depp fans who felt he could do no wrong. Okay, I'm not going to critique the article. While, quote, believe women never became the rallying cry some wanted it to be, more women began to believe they would be believed. Many experts in the field of gender discrimination and domestic violence, however, feel that Depp v. Heard verdict and the online harassment of Heard in the trial leading up to it could shake the confidence of women who might have otherwise come forward with allegations of abuse and slow or reverse the momentum caused by Me Too. I really... A, I hope that doesn't happen, but B, I really think this case needs to be looked at in isolation because it was so public because of their celebrity. This case might chill other celebrity, but I don't think people who aren't worried about their cases being televised are going to be as worried, but we'll see. I'll be interested to see if any of the prosecutors I know have people come in and say, I don't want to prosecute this because of Depp v. Heard. I haven't heard anyone say that. Similarly, The Hollywood Reporter wrote, quote, at the height of the Time's Up movement, stars rallied in support of women during high-profile cases against the likes of Harvey Weinstein and Bill Cosby. The absence of such solidarity today has some Me Too proponents worried about the future of the movement. The movement only survives if you support people who were abused. The concerns about solidarity were well taken, as demonstrated by the running commentary from members of the LawTube, quote, panel. Notwithstanding the diversity of political and cultural perspectives among members of the group, this trial wore on the virtually unanimous opinion among the LawTube was that the harsh glare of the courtroom and the skill of Depp's legal team left Heard's credibility, appeal, and chances in tatters. That was a hard sentence for me. I don't know why, but it was. The sentiments were well represented by a description of the moment reported in the Los Angeles Times article cited above during LawTuber Emily D. Baker's live stream of the Depp Heard trial to her live 128,000 viewers. I'm just going to take a moment to say thank you for using the D. So many leave the D out, and it's an important and critical central part to the EDB. So thank you for that. We did have 128,000 viewers. By the end of the trial, we peaked at 370,000 peak concurrent viewers. I guess we're talking about me now? Okay. The purple-haired baker, accurate. I am. The purple-haired baker is a seemingly natural ally of Me Too advocates, having told the Times. Also true. I said when we went into this case, at the beginning of the very beginning of watching this trial, and my coverage of this case was minimal before the trial because I wanted to see what happened when the evidence unfolded. I did not go look at the leaked audio. I did not go look at what was being presented on social media. I wanted to see what happened in court, and I let everyone know my natural inclination, my deep down district attorney guts wants to believe Amber Heard. As I'm watching the evidence, I am trying to keep in mind that my natural inclination is believe Amber Heard. That is my natural leaning. That's how I came into the trial. The Amber Heard fans will strongly disagree, but that is how I came into this trial. Because that's where I lean. I lean towards we believe victims and we can ask questions. Because again, the stories have to be supported by evidence when we take them into a court of law. But that is where I start from. I start from trust but verify. That's where I start. So accurate. I think this is accurate about me. The purple-haired baker is a seemingly natural ally of the hashtag #MeToo advocates, having told the Times reporter, quote, "I hope that as a female attorney streamer that has worked in the criminal context, I can bring not just sensitivity to the topic, but also asking the appropriate questions if the evidence doesn't match the testimony in the most compassionate way possible. There's just a way to have that conversation without being hateful." I absolutely stand by that. I 100% stand by that. Sometimes I'm more articulate when I read myself back. Baker was not, however, prepared to go beyond empathy and sensitivity to giving her viewers her straight take regarding Heard's and her lawyer's performance in the courtroom as described in the article. I think that's fair. Emily D. Baker is exasperated. It's true. In the penultimate week of the Amber Heard Johnny Depp defamation trial, Baker at time raises from her seat in her home studio or fans herself with a small blue book that was of the federal rules of evidence as she delivers a steaming critique of Heard's attorney, Elaine Bredehoff. This is preposterous, Elaine. Wait, where was this from? Is this in the LA Times article? I've forgotten. This is preposterous, Elaine. Let's see if I can read myself in my own voice. This is preposterous, Elaine. You don't do speaking objections. Baker 44 sees as red lights flash to indicate another 1,000 subscribers have signed up to her channel. A so-called super chat message flashes across the screen from a viewer who paid $10 to let the audience know she thinks the judge is being too easy on Bredehoff. This is a mess. The jury's going to see it's a mess, Baker adds. I feel like that's true.
Elaine, this is a mess. Thank God we didn't have the voice changer during this trial. It would have been a mess.
All right, I have to keep an eye on the time, so let's keep going. Baker was right, as were other law tubers. The jury returned a verdict of $15 million for Depp. Well, thanks, Ron Coleman. I was also exasperated. I don't know what purpose I serve in the lawsuit, but great. But great. This is just it's Emilyception. It's Emilyception. It absolutely is. I'll have to go back and look at the LA Times article. I've truly forgotten what was in there. Everything was kind of a blur. But I was exasperated by the end of trial. Here's why. I think that the hate towards Amber Heard oftentimes went too far. I think there was a lot of mockery that was just distasteful, but I think some of the hate did go too far. Absolutely. And so I was frustrated by some of that, but I was also frustrated by the way that the pro Amber Heard crowd was so hateful, so name calling, so blaming, hateful. That was also disappointing. So it was on both sides. Nurse Liz, good to see you. All I want in life is to be quoted as exasperated in a lawsuit. It's a lawsuit quoting an article quoting me. It's just or quoting the reporter's perception of me. I will have to send this and let them know that their article from the LA Times has made it into this defamation lawsuit. Let's go with Christopher Bouzy, the serial entrepreneur. As we have to zoom, we're only 6 of 46 pages in. On his personal website, ChristopherBouzy.com, Bouzy describes himself as a serial entrepreneur, software engineer, and political maven. Huh. Words cannot express the feeling you get when building a product with a keyboard and a mouse and then release it into the world for millions of people to use. On Information and Belief, defendant Bouzy is not a software engineer. His LinkedIn profile does, however, describe him as having been employed as a computer service technician for the New York Department of Education from September 1998 to November 2000. The shade. There's some shade there on Information and Belief. I'm going to cut this out. It's going to be in every paragraph because, again, allegations and shade. Defendant Bouzy never, quote, released a, quote, virtual product that has been used by millions of people. More shade. More shade. More shade. And more of you still shocked that you are blocked. I don't know. Political maven? I don't know. I don't know. Maven's an interesting word, though. So, let's see. A previous company of his called Comcore, however, did release 4 programs: Wallet Cloak, a system for encrypting and hiding cryptocurrency wallets; Music Chow, a free music downloading application. How is that not like LimeWire? ByteScent Bounty. ByteScent Bounty, a fun and easy way to discover new apps and games while getting rewarded. Okay. And ByteScent, the first peer-to-peer rewards network powered by blockchain technology. So lots of crypto stuff, which by every indication have all been used by virtually no one. Oh, there's more shade. Because he is a serial entrepreneur, Bouzy's Comcore was not his first failed venture. The distinction belongs to Insight Concepts, Inc., which in 2003 issued a press release making the following astounding claims. The new face of software, New York-based company Insight Concept, redefines the term unique software. Today, Christopher Bouzy, this was August 31st, 2003. Today, Christopher Bouzy, the CEO of Insight Concept, announced that the company is weeks away from releasing software that will successfully determine if a person is telling the truth or not. Wait, what? What? Wait, what? The company has completely designed the software for the average home user and boasts if you can click the mouse, if you can click it, then what? Then you can use the software. Software engineers from the company claim the software can effectively detect slight anomalies in human voice when someone is lying or telling the truth. You wanted to create a lie detector software? What? And the software has a 90 to 95 success rate. According to who? How do you test that? What? How do you test it? Well, some experts question the morality of using such software. 2/3 of the 1,500 American survey. You surveyed 1,000 people. You surveyed 1,000 people. Surveyed said they would use the software at least once. Yeah, they probably want to try to see if it works. I'd use it once to try it. That's what they're saying. A survey of 1,000 people. What? How did you Stop, Emily, stop the rabbit hole. We're not diving down this rabbit hole. We have to read the lawsuit. I could run commentary on this press release for an hour. I have to keep going. In the back of everyone's mind, we often wonder if a person we are dating has something to hide. Google it. No, 2003. Interesting. Maybe just have a conversation with people and be perceptive. Maybe. Has this guy ever ripped on body language experts? I need to go and look. I wonder if he's ever ripped on body language experts, because isn't this oh, we can detect a variance in the voice. I can vary my voice. Kaylee, I'm about 40 minutes behind. I have never even tweeted a tweet, and he has blocked me. Yep, it's who you follow. The software now gives a person the ability to determine if their partner is being completely honest. Oh, so we just don't trust the humans we're dating. Maybe trust the people you're dating. Maybe have good communication. Somebody in the chat. I love this. Wait, where is it? Hope Cat said Emily has more people watching than the people surveyed. Across platforms, we have over 18,000 people watching at the moment. So that's fair. Don't forget Ricada Law was also attacked by Bouzy. I don't remember that. I will have to go back and look when he got by Bouzy, and Rejoice when he got kicked off of YouTube. I remember Bouzy and some others taking a victory lap when Ricada got yeeted. I wasn't surprised by Bouzy taking a victory lap, and some of the pro herd people took a victory lap as well. The 28-year-old CEO started the company in 2000 to develop software other developers were not interested in developing. Well, because most people aren't going to be like, hey, I need a software to see if my partner is lying to me. Like, if you're there, you probably should go to therapy or have a conversation with your partner or not be in that relationship. Just in my opinion. The 28-year-old CEO started the company in 2000 to develop software other developers were not interested in developing. Insight Concepts has made it successful developing less than common software for the home and business consumer, and the company has reported an annual gross profit of $3.5 million in downloaded and CD-ROM sales. The company recently released a new version of their award-winning software, Cloak. Cloak is a stenography encryption application that allows users to encrypt and hide file within image files. So surveillance and hiding. Interesting. I was permitted to take Cloak for a test drive, and I was impressed within 5 minutes. With the 5-minute learning curve of the software, I was able to navigate through the steps of this to successfully encrypt the file. So wait a second. It's a software to detect if someone's lying to you and then hide what you're doing in image files. So why do you need to hide things? So the person is like, hey, I can hide what I'm writing on the internet in an image file, but I can also see if you're lying to me. This is a very strange suite of software. I have questions as to why this suite of software was needed. Don't trust your partner? Hide what you're doing from them in an image file and then see if their voice changes and if they're lying to you. I don't have enough red flags for this. This is red flags to me. This is the software somebody purchases who's also trying to hack into your phone to get your location, geolocation all the time. That's the person who wants to buy this for me. Truth and Beauty says, I want to know if you're being deceptive by being deceptive. This is just, it's an interesting press release. Okay, despite the claimed success of this unique, if not morally troubling software release, Insight Concepts was dissolved in 2004. Wait, they had a $3.5 million year and then dissolved? An annual gross profit of $3.5 million and then you dissolve? I have questions. Shortly after joining let's see. Bouzy first achieved notoriety, however, operating another crowd-funded project, a cryptocurrency bank called Blackcoin. Shortly after joining one such forum, bitcointalk.org, in March 2014, under the iconic expert username, at least his opinion of himself is high. Bouzy introduced himself as a software engineer who was working with friends in the finance industry on a new product, specifically a non-reloadable, single-use cryptocurrency-based payment card called Blackcoin. Shortly thereafter, iconic expert started using the forum to solicit donations that he said would be used to help cover the cost of writing and distributing press releases to help support Blackcoin in the market, which he did again several weeks later. 2 weeks later, at the end of 2014, Bouzy again requested crowdfunding, this time $12,000 to finance, quote, Wall Street promotional event, at which 50 women wearing branded t-shirts would hand out Blackcoin cards in the financial district. In early May, supporters, investors, and purchasers of Blackcoin cards were turning against iconic expert, who was accused of trying to control and censor the group, misstating his credentials and misusing donations. Despite claims by Bouzy that the actual cards had been shipped, Bouzy never disputed online claims that most purchasers never received them. Bouzy, being a serial entrepreneur, was also involved in controversy involving accusations of other unethical pumping, otherwise known as pump and dump schemes. This gets into Bot Sentinel. We're going to have to zoom because I am going to have to wrap in just a few minutes. In 2018, defendant Bouzy turned his attention and his crowdfunding away from cryptocurrency to social media. Although formed as a New Jersey for-profit operation, defendant Bot Sentinel solicits donations, stating on its website that it's a crowd-funded project. Bot Sentinel is a service Bouzy founded in 2018 that describes itself as, quote, helping fight disinformation and targeted harassment on Twitter. We believe, according to the service's website, that, quote, Twitter users should be able to engage in healthy online discourse without inauthentic accounts, toxic trolls, foreign countries, and or organized groups manipulating the conversation. Bot Sentinel describes itself as a free, nonpartisan platform developed to classify and track inauthentic accounts and toxic trolls. The platform uses machine learning and artificial intelligence to classify Twitter accounts and then adds the accounts to a publicly available database that anyone can browse. I don't know how much longer that'll be working now that Twitter has a new owner. Bot Sentinel's claims for a technology, that is, its ability to detect and rank quote-unquote bots on Twitter, has been taken for granted by a number of non-technical publications, but others have raised significant questions about the application. While the name Bot Sentinel suggests that it flags automated Twitter accounts known as bots, the Bot Sentinel website explains its operations as follows. Bot Sentinel uses machine learning and artificial intelligence to classify suspicious Twitter accounts, and then we store those accounts in a database and track each account daily. We use the data to collect and understand how these accounts affect public discourse and how we can minimize their negative influence. Does negative mean that you don't like? Does negative mean influence you don't like? Our team developed our machine learning model using 2,500 ordinary Twitter accounts. Picked by who? Tweeting about politics, current news, and other various topics. We also used 2,500 troll bot accounts we identified by who? By examining the text of their tweets. So you know they're a troll bot by the text of their tweets? They could be a person. In total, we use a combined 5 million tweets from ordinary and troll bot accounts to build our model. And someone's decision-making. Yeah, Miguelina, let's end the poll because I'm going to have to wrap soon. We might not get through this, which means we'll have to circle back on Thursday. The herd stuff took longer than I thought, and I do have an appointment that I have to get to shortly. On its website, Bot Sentinel defines troll bots as human-controlled accounts who exhibit toxic troll-like behavior. Oh, so they're not bots. They're people who you don't like. Some of these accounts frequently retweet known propaganda and fake news accounts and engage in repetitive bot-like activity. There is very little that is either actually high-tech or rigorous about this definition, including as it does such subjective and indeed highly contentious categories like toxic troll-like behavior, propaganda, and fake news. So this is getting more into Bot Sentinel. I want to take a look. We'll dive deeper into Bot Sentinel. There are words on this that I can't say and won't put on the internet. But because of this subjectivity, however, Bot Sentinel's ratings are widely inconsistent. For example, Bot Sentinel ranked this Twitter account as normal, but it's using all kinds of slurs. We're going to zoom past the slurs. At the time, Bot Sentinel rated plaintiff's Twitter account, Nate the Lawyer, which uses neither racial nor other slurs or calls for violence or death against any person or ethnic group, as disruptive. See, this is where the rankings are very interesting. On information and belief, Nate the Lawyer's disruptive rating is based on little more than the personal preferences, bias, or agenda of defendant Christopher Bouzy. In other words, while Bot Sentinel gives and look, you might be tempted to go run accounts. It will track you. It will track you and everything you do if you run accounts on their website, just as a FYI. So just know if you use it, it will track what you are doing and where those requests are coming from. It is for this reason that Amber Heard's team turned to Bot Sentinel as the linchpin of a media campaign that would blame a secret network of misogynists utilizing bots and platform manipulation, and not the revelations about her conduct that emerged during the trial or the jury verdict as the reason for Heard's plummeting reputation. So then they go into Bot Sentinel's social media hit job. Let's see. They talk about the May 3rd, 2022 Rolling Stone article. Bouzy guns for LawTube. In September 2022, Bouzy turned his censorious attention on LawTube, who, as set forth above, had been critical of the defense presented by Bot Sentinel's high-profile client Amber Heard. Various LawTubers, including plaintiff, had also taken to sharing critical takes of the widely reported Bot Sentinel claims of widespread trollbot activity engaged in coordinated social media attacks of Heard. Bouzy, offended by this criticism, I mean, speculatively, but okay, started using his Twitter account to focus attention on LawTubers he deemed guilty of some kind of toxic troll-like behavior, propaganda, and fake news. He deemed inappropriate on Twitter and demanded that YouTube delete their accounts. Yeah. On September 17th, 2022, Bouzy set his sights on plaintiff tweeting, "Next up is Nate the lawyer." Oh, he did do that. He went from being the son of, this. Yvette said, "Emily, I'd voted no, I hadn't been blocked, only to check again and now find I'm now blocked." It's funny. The blocking is real. We ended the poll. Are you blocked by Bouzy? No, 58%. Yes, 41% with 8,000 votes. 41% of you at 8,000 votes have been blocked by Bouzy. That's astro-fucking-nomical numbers of blocked by Bouzy. 8.1 thousand votes, more than his sample size of Twitter accounts. 41% of you are blocked. That's bananas. This is offensive, by the way. We're just be angry on behalf of Nate if you want to. On September 17th, 2022, Bouzy set his sights on plaintiff, tweeting, "Next up is Nate the lawyer." He went from being the son of two crackheads, his words, a drug dealer, his words, a cop and a prosecutor, to attacking journalists and me on social media. You would think someone with a law enforcement background would know better. Nate talks about his background. I don't think maligning him for his background is ever okay. I think instead asking Nate his story, because Nate and I talked on the live stream about being the first person where he lived in the projects to go to law school and the support he got from those he lived around. Nate has an incredible story. To try to use that against him is disgusting. My opinion. Bouzy later deleted this tweet because it's disgusting and it backfired. To try to pull someone down for overcoming a background with parents with addiction. To try to pull someone down for that is gross. It's just gross. Attack the things Nate says if you don't like what he says. Say you don't like what he says. You don't like his takes. Fine. But Bouzy later deleted this tweet, as well as the tweets reproduced below, in which he doubled down on his attack on Nate's veracity and professional qualifications, publishing yet more tweets, also later deleted, insisting that Nate the lawyer was lying about his credential, would soon need a lawyer to defend himself against legal claims, and engaged in deceptive advertising. I'm sure there's a reasonable explanation for why we can't find him in the database where he claims he practices law. He might want to retain a lawyer. And then they link it to the attorney services. Nate spells his name online differently than he spells it with the bar. And it's almost like when you work online, you get fucking harassed. Almost like that, Bouzy. YouTube should really verify certain professionals' licenses. Actually, I agree. I agree with that. They do it for doctors. I agree that they could do it with lawyers. I agree. I don't disagree with that. Before allowing them to claim they are doctors or lawyers, they actually can do it with doctors. I think they could do it with lawyers. I think that's fair. I can't tell if this guy is a legit lawyer or just a social media lawyer. Where does he advertise his services? Advertising services does not a lawyer make. He is licensed. Quote, "While Nate the lawyer attempts to impress his gullible followers with a non-issue, do not come for the chat. Our audiences are quite smart." I still can't find his bar association number or the New York Times, Forbes, and NBC article he claims he was featured in, just social media profiles. You're a good researcher, Bouzy. That was sarcasm. As a self-described authority on Twitter trolling and manipulation, Bouzy was accurately cognizant of how the engagement he was generating on Twitter through his attacks on the popular Nate the lawyer could be converted into an advertisement for himself and bought Sentinel, so he published one. While we wait on Nate the lawyer to locate his law license and the links to his New York Times, Forbes, and NBC articles, I will share my New York Times, Forbes, and NBC articles. The next day, having learned that Nate the lawyer was in fact a New York attorney, Bouzy conceded on Twitter that his earlier claim was contrary was false, but Bouzy, who for years has falsely claimed to be a software engineer, repeated his assertion that even if plaintiff really was a lawyer, he still was lying about having been a prosecutor. As explained, that is not his real name. Yes, he was a cop and he became a lawyer in 2016. He was never a prosecutor. So we've gone from he's not a lawyer to he's not a prosecutor. It's okay, Muffin. Just say it. You were wrong. It won't hurt. That's the best part of this tweet thread right here is the response. I'm going to have to start saying that. It's okay, Muffin. Or we might have to finish this on Thursday. Shit. Bouzy has no, let's see. Bouzy has no factual basis whatsoever for this false claim. Eventually, other Twitter users accused Bouzy of either doxing plaintiff by revealing plaintiff's real name, which, like many social media users, Mr. Brody had chosen to keep private, or recklessly disregarding the truth of the repeated claims, lying about being a lawyer and former prosecutor. Bouzy responded that his earlier misrepresentations about Brody were not, as some were suggesting, the result of mere negligence. Rather, Bouzy explained he had knowingly and willfully published false statements to his 120,000 Twitter followers for tactical purposes. Christopher Bouzy, or I don't know what it's responding to, but or you are just unable to read between the lines. I already had the information and was waiting for someone else to tweet it so I wouldn't be accused of doxing. Reread this thread slowly. What that says to me is that Bouzy knew Nate was a licensed attorney while accusing him of not being a licensed attorney. That's what that says to me. Oh, I knew it. I knew it. I just didn't want to get accused of things. Americans don't spell practicing with an S. And then he goes into all this stuff. I can't see the entire tweet. I remember it though. Finally realizing he had been caught publishing a string of false and defamatory claims, Bouzy conceded the falsity of the claims about plaintiff's background and credentials. The headline about Depp that he sued over was up for less than like 12 hours. He didn't win that suit, but you can sue over something that doesn't stay up. Bouzy wrapped these concessions, however, in a pathetic attempt to troll Nate the lawyer by accusing him of being a Twitter troll and a grifter. The later epithet, meaning that Nate engages in grift or financial fraud. I think in the context of the law, he was a SUNY campus cop for 10 years, and he was then admitted to their law school. He joined the DA's office in 2016, and 6 years later, he became a Twitter troll and YouTube grifter. Quite the resume. I bet Bouzy couldn't hold the attention of an audience the way Nate does. Just saying. Even Bouzy, however, must have realized that these claims, while false and defamatory, were relatively anticlimactic compared to his earlier narrative of Nate the lawyer not being a lawyer at all. Then we get into the tweets where Bouzy is attacking Nate, saying that he's trying to fit in with his Caucasian peers. Then we get into the claim of criminal conduct, which needs more time to be discussed. Then we get into Bouzy trying to dunk on Nate more tweets, and we're only halfway through. I am so bummed that we are not going to get to finish this today. I'm going to have to finish this on Thursday. I would keep streaming if I didn't have an appointment. I'm going to just leave you with the claims here. First claim is defamation per quad. Next is defamation per se. Third is false light tort, which is a branch of defamation. Fourth is intentional interference with prospective business advantage. And those are the causes of action. And then we've got exhibits. And we need to go through the exhibits. All the exhibits. So we're going to have to finish this on Thursday because, well, Amber Heard interrupted. And we're going to finish Nate's lawsuit. There is so much more here. With that, I'm sorry that we have to leave early. For every single person who super chatted, I'm sorry that we did not get to them. I will be able to see them and answer questions on Thursday as we finish up this stream and do a longer questions. Unfortunately, I have to get to an appointment that I am now very much going to be late for. So we will go through the exhibitees on Thursday. We will go through the rest of this on Thursday. Thank you for being here. Thank you for being law nerds. I'm sorry to have to scoot. We have a new episode of The Emily Show tomorrow and a stream on Thursday. I talked way too much, and we are going to get through the rest of this and questions on Thursday. Thank you, thank you, thank you. I am never scheduling anything on Tuesday again, ever. I'm just not. So with that, I will say goodbye. Thank you for being here. I'll see you soon. Bye, guys. Oh, do the YouTube likey, subscribey things. Thanks. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.